Estate planning can be really complicated stuff. Sure, there are judges and laws and rules, and those are pretty complicated in and of themselves. But you have this extra layer of emotions, of mom passing away, of mom becoming incapacitated, of that brother I haven't seen in 35 years. There's so many emotional things that also come into play, and both the legal and the emotional side of things, they interact and they impact each other in very, very important ways. And there must be something in the water, because in the last couple of months I have had so many calls from people from both sides of the coin. I've had people call and say, hey, you know, I'm a trustee, my mom or dad passed away, and I now have to tell all the beneficiaries out there about the trust. What do I do? On the other side of the coin, I've had people call and say, you know, my dad passed away 6 months ago and his lawyer won't return my calls. I haven't heard anything. I don't even know. I know I'm a beneficiary, but I don't know what I should get. What is the right way to get a copy of the trust? So the rule in California is this. Within 60 days after a trust becomes irrevocable. A trust usually becomes irrevocable when someone passes away. So irrevocable just means it can't be changed. So think about it this way. You know, if mom passes away, you know, we can't talk to her anymore. We can't look her up and with the Ouija board and say, hey mom, did you want this? Did you want that? Who should get your pearls and who should get your rings? It's all, whatever it is at the time of death, it's irrevocable. That is what it is. And at that point, within 60 days, typically the trustee needs to provide a notice to all the beneficiaries named in the trust and what are called heirs at law. And these are the closest living relatives. So for example, if mom named her 3 kids and grandchildren in the trust, then the kids are getting notice as heirs at law. They're her closest living relatives, and they're getting notice as beneficiaries. The grandchildren are getting notice as beneficiaries. So everyone is entitled to a notice, and in the notice it says, hey, you're a beneficiary or a possible beneficiary. If you'd like to see a copy of the trust, please let us know and we'll provide it to you. But the other side of things is when and how should I ask for an actual copy of the trust? And in this respect, use proper judgment. If you are in a family with fissures, if you're in a blended family of his, hers, and our kids, and the parents have passed away, and things have never really been quite right with the kids, don't go in and ask the trustee on the morning of the wake or the morning of the mass when 150 people are showing up to have food and say, hey, I want to sit down right now and I want to read a copy of the trust. Can you make a copy of it for me? Or the first time the family all has a chance to get together and look at pictures and laugh and cry and divide things up, don't go in there and bulldoze your way in and say, hey, what am I going to get? And how come my kid is getting less than all the other kids? Those things really stick with people. I have folks remembering 20 years before administering a trust for someone, and what do they say? They don't say, oh, that was so hard, I hated dealing with that bank. They say, when my cousin came in and he made such a hard time for me, that body wasn't even cold yet, and he was asking me what he was going to get and how he was going to get it. That stuff sticks with people in their heart. And the most important thing is the relationships that we have. And so how you ask and how you approach people, use common sense and common judgment. A lot of times the legal things have a way of perfectly working themselves out if everyone gets along and no one feels like salt was poured into a wound. I hope you found this practical advice useful. Thank you so much for watching.